And I do believe he's prepared to make this plea today knowingly, voluntarily, and intelligently.
All right, Mr. Gardner, how old are you?
36.
How far did you go through school?
I have a GED.
Are you a U.S. citizen?
Yes.
Are you able to read, write, and understand the English language?
Yes.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
No.
Have you ever been diagnosed with or treated for any mental illness?
I go to mental health right now. I have anxiety and been diagnosed with depression.
Are you being treated for that?
Yeah, I have prescribed medication for it.
What medication?
I know one of them is syrup to help me sleep. Another one is for moods. I forgot it's called. I forgot the name of that one. I can get it.
When's the last time you took any of those?
I take one every day and then one at night at bedtime, so I take both of them every day.
Did you take it today yet?
Yeah.
Does it affect your ability to understand what's going on here?
No, sir.
Okay. Did you get a copy of the indictment in this case?
Yes, sir.
It's my understanding you're going to plead guilty to a lesser included offense in count 1, attempted having weapons under disability, a felony 4, as well as the forfeiture specification, and also count 2, improper handling of firearms in a motor vehicle, a felony 4. And the remaining charges will be dismissed at sentencing. Is that your understanding?
Yes, sir.
All right, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you some questions. If you don't understand the question, stop me. If you want to talk to Mr. Petropoulos some more, let me know, and I'll give you more time. Do you understand that?
Yes, sir.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes, sir.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them testify. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
You have the right to testify at trial if you want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, sir.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you could not afford to hire a lawyer, one will be provided at no cost. Do you understand that?
Yes, sir.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes, sir.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes, sir.
Do you have any questions about any of these rights?
No, sir.
Do you still want to plead guilty to these charges?
Yes, sir.
Do you understand by pleading guilty, you're fully admitting your guilt to the charges?
Yes, sir.
You understand by pleading guilty to these felonies, you're voluntarily giving up your freedom for whatever period of time I sentence you to prison, to jail, or to community control.
Yes, sir.
And the lesser included offense in count one, the attempt at having weapons while under disability is a felony 4. It carries an 18-month maximum prison sentence and a $5,000 maximum fine. Do you understand that?
Yes, sir.
Count 2, improperly handling firearms in a motor vehicle is also a felony 4 with an 18-month maximum prison sentence and a $5,000 maximum fine. Do you understand that?
Yes, sir.
If you plead guilty to the forfeiture specification in count 1, you're voluntarily giving up the items listed. Do you understand that?
Yes, sir.
Now, I could give you a consecutive sentence. That means one sentence after another for the separate offenses. If I did that, you face a maximum prison sentence of 36 months and a maximum fine of $10,000. Do you understand that?
Yes, sir.
Are you presently on post-release control to the parole authority?
Say that again?
Are you presently on post-release control to the parole authority?
No, sir.
You understand that your felony conviction prevents you from owning or possessing a firearm.
Yes, sir.
You understand that if a prison term is imposed in this case, you might have to serve a period of post-release control for up to 2 years under the parole authority.
Yes, sir.
If you are placed on post-release control and violate any conditions, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes, sir.
If that violation is a new felony, then you could get an additional consecutive prison sentence for that violation. Do you understand that?
Yes, sir.
And if that were to occur, the maximum prison sentence for the violation would be the greater of 12 months with the time left under post-release control. Do you understand that?
Yes, sir.
Do you understand that if a prison term is imposed, you are eligible for judicial release?
Yes, sir.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 36 months. Do you understand that?
Yes, sir.
Has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No, sir.
Has anybody promised you what I will sentence you to in this case?
No, sir.
Do you understand I do not have to follow a sentencing recommendation of either the prosecutor or your lawyer?
Yes, sir.
Have you had enough time to talk with Mr. Petropoulos before pleading guilty today?
Yes. Yes, sir.
Has he discussed everything about your case and answered all of your questions?
Yes, sir.
Are you satisfied with the advice he has given you?
Yes, sir.
Have you been threatened or coerced in any way to plead guilty today?
No, sir.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, sir.
Do you have any questions at this point?
No, sir.
All right. Ms. Contour, if the case went to trial, what would the evidence show?
Your Honor, the case went to trial. The evidence would have shown that on June 15th of 2025 in Lake County, state of Ohio, the vehicle that the defendant was operating was pulled over for a traffic infraction. During a probable cause search of the vehicle, a loaded firearm was found in a bag underneath the front driver's seat. That was sent to the Lake County Crime Lab, confirmed to be operable, and the defendant does have a prior conviction for a felony offense of violence, robbery, in the Cuyahoga County Court of Common Pleas from 2009.
All right. Mr. Petropoulos, anything to add to those facts?
No, Your Honor.
All right. Mr. Gardner, did you hear what Ms. Contour said? The facts would show if the case went to trial.
Yes, sir.
Are those facts true?
Yes, sir.
All right. What is your plea to the lesser included offense in count 1, the attempted improper handling of, or the attempted having weapons while under disability?
Guilty, sir.
What is your plea to the forfeiture specification?
Guilty again, sir.
And what is your plea to count 2, improperly handling firearms in a motor vehicle?
Guilty, sir.
Mr. Petropoulos? You have them initial on page 2 in the margin where I put the psych meds in there.
Initial here, this is just that you took your psych meds because otherwise would say no.
Initial.
Just initial. And then, sign date. Today's the 29th. Then he's initialed in the margin with the medications. He also signed on the final page dated, and I've also signed it.
Your Honor, I did witness both the defendant as well as his counsel sign a written plea of guilty, and I signed it as well.
Mr. Gardner, is this your signature on the written plea of guilty?
Yes, sir.
And did you sign it voluntarily?
Yes, sir.
You want me to accept your written plea of guilty?
Yes, sir.
All right, I'll accept the written plea of guilty. The defendant was present with counsel, advised of all of his rights, made a knowing, intelligent, voluntary waiver. He understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, voluntary. I will accept his plea of guilty and find him guilty of the lesser included offense in count 1, attempt at having weapons with a disability, a felony 4, and the forfeiture specification, and to count 2, improperly handling firearms in a motor vehicle, a felony 4. I'll refer this for a pre-sentence report. Sentencing will be February 12 at 1:30 p.m. and the bond is continued. Anything else, Ms. Contour?
Nothing further, Your Honor.
Mr. Petkoulis?
No, Your Honor.
All right, we're adjourned.
All rise.
All right, this is 24-447, Isaiah Eady, probable cause hearing on a probation violation. First violation cited by Euclid PD for open container physical control. You understand that charge?
Yes.
Second violation, admitted use of cocaine on December 18th. You understand that charge?
Yes.
Third, cited by Mentor PD for possession of cocaine and driving under suspension, December 18th. You understand that charge?
Yes.
Mr. Goldberg, how does he want to proceed on this problem?
Your Honor, he's executed the waiver of the preliminary hearing on these PVs. If you allow me to approach.
Yeah. All right, and then we'll set this for a final hearing, Mr. Goldberg, if you get a date from Maria, but what do you want to say otherwise?
Your Honor, I would respectfully ask the court to consider admitting Mr. Eady to bail. Now, I understand that this is not an adequate performance on community control. Continues to have a drug problem, but at the same time, he's been working full-time. Just-in-time staffing in Mayfield, Ohio, has employed him. He indicates he's working 40 hours a week. He's got stable residence in downtown Cleveland. He has 2 children, age 5 and 3, and he has a child on the way. He understands he needs to get cocaine out of his life. I know he should have done that before coming before this court, but I would also ask you to consider that when he got the OVI or the physical control in Euclid, he told his probation officer when he got arrested in Mentor and bailed out, he also told his probation officer, knowing he'd be locked up. He's been locked up for the last 10 days, 11 days. He is productive when he's outside of the confines of the jail, Your Honor, and we would definitely approach the county prosecutor here to try to resolve this new case. I would like to see the evidence because, you know, there is some question of how the stop occurred, but that's besides the point with regard to this PV. But we would move that along as quickly as we can, and we would accept, obviously, any conditions the court deems appropriate. Obviously, Mr. Edie can't drive.
But he was. But he was, right?
He was,
He's
yes.
driving on a suspended license.
He was driving. He can't drive it, you know, obviously a electronic monitored home arrest or some other type of monitoring would assure that he would be either at home or at work or, you know, doctor's appointments or things like that. But to have him sit in that county jail indefinitely, I would submit to the court would not be in the best interest of the people of Lake County, just because of the expense involved when he could go home and be monitored sufficiently there and actually provide for his family until we can work out this, what is probably going to be a felony of the 5th degree. Thank you.
Yeah, the more, well, on this case he's on probation for was an F3. And,
That is correct.
and that was after, Mr. Edie, you had been to prison
Correct.
in January of 22, and then were released about a year and a half later, placed on PRC, and they're not a glowing report from your parole officer while you were on PRC. So within 6 months of being released, you pick up this charge, this F3 charge, March of 24, and I put you on probation and attempt to address what had become a very quickly disturbing pattern on your part with this prior, and send you to long-term treatment. You get out when, in November?
Yes, sir.
November what?
November 24th.
You get out on EOCAP November 24th, and here we are in early December in Euclid with some involvement in cocaine. How that turns out, I don't have any idea, but it's an open container, physical control. And then 3 weeks later, 2 weeks later, you're doing this in Menor with some pretty well-known drug folks out this way. So I'm not going to let you out on bond. Hopefully, Mr. Goldberg can get a hold of the prosecutor and we can get these things resolved. But you're not to be trusted at this point. Okay, you got a 5 and a 3-year-old, and you got a child on the way, and you're out after your recent past of pretty serious offenses, screwing around again. So you're going to stay put for a while. Mr. Goldberg, get another date from Maria.
All rise.